All rise. Here, Court of Appeals of the State of Michigan is now in session. The Honorable Michael J. Reardon, the Honorable James Robert Redford, and presiding the Honorable Randy J. Wallace. All persons have been hearing draw near. Your petition shall be heard. God save the United States, the state of Michigan, His Honorable Court. Please be seated.
Good morning, everyone. Welcome to our September 2025 case call. I have the distinct pleasure today to be sitting with my colleagues, Judge Reardon and Judge Redford. The only thing I want to say to you before we get started here today is some of the cases before us involve minor children. And so if you're going to make reference to those children, please use their initials as opposed to their full names. And with that, let's go ahead and dive in. The first case on our docket is the person that was endorsed has waived oral argument. So I'll call the case. It's 3-7-2-3-8-3. And no one being endorsed for oral argument other than the person that waived. That case is submitted on the briefs. So we'll call case number 2, which is 3-4-8-2-1-4.
Morning, Mitch Foster for Delanius Jones. I'd like to reserve 5 minutes for rebuttal if necessary. So the jury never knew why Delanius was in a wheelchair. And that when it comes down to evaluating everything, that's the key in this case. Why was he in a wheelchair? Was it a bad knee where he had surgery? Maybe he had double hip surgery, couldn't walk temporarily? Severe ankle or Achilles injury? The jury didn't know. They were never told. So the jury can assume that Delanius was fully capable of committing a sexual act or experiencing pleasure during a sexual act. They didn't know any of that. And with that, Delanius was denied effective assistance of counsel. So questions the jury never pondered, and they should have, is if Delanius had no feeling in his penis, why have the complainant give him oral sex? What's the point? What's the purpose?
All of your arguments directly contradicted by the Michigan Department of Corrections report concerning his feeling.
Well, Judge Reardon, yes and no. None of those MDOC reports were backed up by testimony from doctors. It's almost like form written. Once it's in the report, it keeps repeating itself.
Well, they indicate he did in fact have sensation below the nipple line from around 2012 to around 2022. As recently as 2022. So in 2012, he said he had sensation below the nipple line. I guess your nipple is your breast.
Mid-chest, yes.
Yeah.
That's completely contradicted from other spots in the medical records, in the MDOC records, where it says he's quadriplegic. He has no feeling in his extremities. So that is that's a matter that should have been factored in by the jury. They can decide, okay, which of these, how reliable are the medical records? Another point is, if Delanius would have just testified about his lack of feeling, there wouldn't have been any medical records. So let's just say.
Didn't he come up with the alibi defense? Wasn't counsel
he
testified
said
he wanted to sort of alibi defense, so that's what they went with.
Well, that wasn't Delanius's decision. He testified that he wanted.
Counsel testified at the Ginther hearing that he wanted to assert an alibi defense. So you couldn't bring in the The whole thing about feeling, if you're asserting an alibi defense, don't they run counter to each other?
I strongly disagree with that.
Oh,
There is
so he
no-
was there not feeling things, but he was not there. How does that drive?
He never said he was there and not feeling things. He said he didn't have the ability to feel things. That's a big
Ah,
distinction.
Okay,
You're saying an alternate defense could have been proffered, which would have been perhaps meritorious.
Most likely meritorious and not in any way conflicted, more complementary. You
okay.
don't, it's not like self-defense where you said, I was there and I shot the guy. This lack of feeling, it doesn't matter where you are. It shows it's an impossibility.
Right, but the trial court conducted a full Ginther hearing in this matter, counsel. And sometimes we don't have the benefit of that, but we do in this case. And heard all those arguments, heard the testimony of your trial counsel and concluded that it was reasonable strategy is my recollection. Is that right?
Yes, but regional strategy, you can't just say regional strategy, Judge Redford. Of
Right.
course, it
No,
has to be.
Yeah,
it
I've
has
seen
to-
those cases.
If it's a flawed strategy, it doesn't matter if you say reasonable or not. So there's no reason he couldn't articulate a reason why he didn't do that. At one point, I think Delaney has testified that the attorney said it would be detrimental to your offense, but he never said why. And at the Ginther hearing, the attorney never said why he didn't do it. He said one reason he didn't investigate was because he thought there would be a cost to the medical records and that it was unlikely the judge would have authorized that large of expenditure. So that was a flawed reasoning and strategy, you know. Even if you can't get the records because of costs, there's no reason not to file a motion and say, I need this, I need to investigate. So you need to, the Trachtenberg cases, you need to undertake a reasonable investigation to decide whether or not to pursue a reasonable defense. So and another reason why the alibi defense was so difficult is because there was a whole bunch of missing dates in that defense. Not only that, for a CSC case, as you know, that there's no requirement that a particular date is specified. It could be any date within the range of the statutory limits of under 13 years old. That's the only requirement in terms of date. Certainly, defense attorneys can impeach credibility by a complainant not understanding or not being able to be clear about dates, but in terms of the essential element to convict, the date, it doesn't matter. So this alibi was over a course of, I think the general information said from like roughly October of 2016 to March of 2017. I'm just going by rough memory. It's somewhere along those lines. It's a 3, 4, 5, 6 month period. And this alibi, I think the alibi witnesses admitted that, you know, they couldn't account for every single one of the dates. So the alibi defense meant nothing. This is a one incident allegation that it could have occurred on any specific date for a matter of a few minutes. And the jury's looking at the alibi and saying, well, so 400 of these dates were he wasn't there. Well, what about the other 100? And so
Right,
the
but
alibi
there were-
defense went nowhere.
So as I understood the record, the defense is basically three-part. Alibi defense was lead. The victim was around the defendant quite a bit, and that was memorialized by photographic evidence after the alleged criminal sexual conduct took place, and that didn't make any sense if she, in fact, she had been victimized by the defendant, that she would be in this photograph that, you know, seems to suggest everybody's doing fine. And that there's some evidence that this child was, I don't know, caught, however you want to describe it, viewing pornography, and that this was just a fantasy and she made it up. So it's sort of a three-part defense. And I agree that the alibi doesn't eliminate 100% of the days, but when the trial court weighed that in at the Ginther, is the what's our standard review of what the trial court decided at the Ginther?
Well, it's a de novo on ineffective of counsel. For factual finding, it's, clear error.
Yeah, okay.
But it's, you don't have to consider anything in terms of the conclusions that the trial court reached. This is all de novo.
So why, when you put all three in there, why do you think, Mr. Foster, that this is something that was incorrectly decided by the trial court, so we should reverse it?
Well, Judge Redford, I think that if that's all you have, then an attorney is duty bound to present the best defense possible. But the defense that the young girl was with the defendant afterwards is a pretty weak defense. I mean, certainly you want to put it in there because you want everything possible to present a defense. But when you actually consider the fact that there's so many delayed disclosure cases where people live lives for
Decades.
years afterwards and then come forward, it's not out of the ordinary, especially when there's an allegation that there was a threat, like keep this secret. So certainly it would be important to include that. But I think if I was here and that was the only issue, he didn't bring the picture of them together at the Country Inn, a year or 2 years later, and that was all, that wouldn't be strong enough for ineffective. I mean, certainly it would have been a wiser decision to include it, and there's probably no strategic reason. But I don't think just that one thing alone would be enough to tip the scales on a case. But when you have something this strong, and when you have a defense expert that does a blindfolded pinprick test on the genitalia of Delanius, and he doesn't wince or he doesn't say anything, I can see if there's not blindfolded, you can maybe fake your way through it and say I didn't feel it, but there an uncontrollable body urge or wincing or something, or this I think it was the chromatic reflex when the doctor rubbed on the inner thigh of Delanius to try to get some sort of involuntary reaction that was negative too. So
It was also years later.
Yes, but there was nothing that's actually more important. People's condition don't get worse.
They don't?
I mean, Judge Wallace, I don't think they would get
Judge
worse.
Wallace has seen a few medical records in his legal career.
Although myself, as I'm getting older, I've got all these joint issues. I would disagree
I'm with
my
you,
own
brother, on
argument.
that.
Right. But when in terms of paralysis, getting more serious here, I don't think that someone's paralysis would get worse. It would stay the
can,
same.
and it
I mean,
does.
I guess it can, but the point is that Dr. Emmer looked at the records. He did his own analysis and he determined that this paralysis was continuing. And he was the only one there was no evidence presented at the Ginther hearing of any other medical doctor to show that, yeah, I examined Mr. Jones and yeah, he's got partial feeling and he would have felt pain on his penis if there's a biting.
But parties had not been required to put in physician testimony in support of a medical record since we introduced the current version of the court rules in 1985. So all of those medical records and everything in them are admissible in this case. And there's a ton of it that rebuts the findings of that physician.
I would say a ton, Judge Wallace, is a inaccurate description. They're probably, this thick on the medical records and throughout it, all the way through was paralysis, no feeling, no sensation. There may have been, there was one
Reporting like 8 out of 10 pain in his lower extremities. He says they really hurt. There's a slew of examples of that.
I understand they're admissible, but the strength of the evidence, I think, is an important factor to consider. And even if all of the medical records were submitted and admissible, you still have conflicting evidence. You still have that juxtaposed with within a page or two, or even on the same page, complete paralysis, no feeling below the nipple line. So, and the tiebreaker would be, Dr. Emmer and his in-person analysis, the blindfolded pinprick test. He used the tuning fork for vibrations, all sorts of things that the jury would have been impressed by. But I don't have to prove here the result would have been different. I just have to prove there's a reasonable probability. And the jury would have come back to, why would he do this if he didn't have feeling? They also would have said, well, did he have feeling or did he not? What do these medical records really say? Do they say that he has feeling? The medical records don't say that he couldn't feel, that he could feel pressure, that he could ejaculate. He also has a catheter. He can't even, he testified that he doesn't ever feel the urge to urinate. So that's directly on point, right in that general area of the body. He says he only drinks a little bit of water, so he just empties this urine bag every, few times a day, but he doesn't ever feel the urge to urinate. And he said he hasn't had a healthy bowel movement in 17 years. So we didn't get in, there was no detail of what that process was, but I think when you put all of the testimony of both Delanius and Dr. Emmer and the medical records, the vast majority of the medical records that showed how he was paralyzed, combined with, contrasted with the other things where there might have been reports of pain. Also, you have not the best treatment in the MDOC, as most people would agree, in terms of healthcare. I mean, sometimes there was testimony that he had a bunkie put a kite in saying that Delanius felt pain and needed treatment to get things moving quicker. That doesn't mean it's true. It just means, okay, it's more urgency. We need to get someone there sooner rather than later. So that was one example of an explanation as to the accuracy of those medical records. But I don't know what more else I can say with regard to the medical records, other than that that's one factor that should be considered. And when you look at reasonable probability, the jury's going to be asking, they're going to be using their own common sense, and they're going to be saying, well, why would this happen? If he can't feel any pain, or if he can't feel any pleasure, why would he have this young child do this to him? And if he did, the other thing that would be, not part of this issue, but why was it alleged to have happened only once if this is something that was this true that it happened? Why would it only be once? But I think those questions the jury really needed to be able to ponder and deliberate on, and they were never even given the opportunity. They never even knew why he was in a wheelchair. So with that, I think it's fully briefed, and as well as the reply brief. And I think the tiebreaker would be the in-person evaluation of Dr. Emmer, just to get to the point of a reasonable probability that there was to be a different result. If there's any other questions, I'll rest for now.
Thank you, Mr. Foster.
Thank you.
Thank you.
Good morning, Your Honors. May it please the court. Melissa Hoover from the Saginaw County Prosecutor's Office, appearing on behalf of the people.
Morning.
I know the court has read the briefs, so I'm not going to belabor any of the points. I just want to address a couple of the things that Mr. Foster raised, and then I will invite any questions that the court might have.
I guess my question is, why not put that in there? It's not counter to the alibi defense. It's not counter to the photograph. It's not counter to she's having fantasies. It is hey, and by the way, also my client, not only he wasn't there, he didn't do it, but if you can't get around that, he doesn't have any feeling because he's paralyzed below from the chest on down. Why wouldn't that have been offered?
Well, A couple of different reasons, Your Honor. First of all, I disagree with Mr. Foster in the sense that I do think that it conflicts with the alibi defense.
In what way?
Well, the testicle removal surgery did take place at the beginning of March, which the defendant has now twice denied under oath. He denied it at trial and he denied it again during the post-conviction proceedings. The mother of the victim, who was also the caregiver of the defendant, she did remain with the defendant through the beginning of March to attend that surgery with him. Again, that was part of the alibi that he was not present in the state of Michigan during that time and has consistently denied that. However, if that was to be raised as a defense at trial, I would have acquired those medical records because the medical records that were acquired by Mr. Foster during the post-conviction proceedings were only for a year's time. So from the time he was shot for a year after that. So all of the hospital records for Mr. Jones from 2008 all the way forward, we don't have any of those.
All right, so your position is that if they raised that, we would have rebutted it and it would have raised more questions about the credibility of the defendant.
Absolutely.
Okay. Okay.
And further about any other claims that he made about the surgery itself, such as the fact that he did not require anesthesia. If he in fact did, then that would have also raised credibility questions about that claim, about any other visits to the hospital during that time frame, which I suspect that there were a number of them. If he would have raised any issues about feeling in his lower region during that time frame, that would have all come out as well. Because we know that he did during at least from 2012 through the time frame that he was imprisoned before these offenses occurred. So there also would have been issues as far as those types of claims. So again, we would have had major credibility issues because I would have obtained all of those records and brought those in as evidence at trial had I known that he would have raised a defense like that.
Did you bring those records in at the Ginther hearing?
No, I did not. No, because I would have had to obtain a search warrant, obviously, to obtain all of those things. So given that it was his burden at the time, I simply raised the what I had located within the MDOC records. Because at that time, I believe that those would have been
Those
sufficient.
we have, so,
Yes.
okay, all right, thank you.
Did he have a boyfriend-girlfriend relationship with the victim's mother?
Yes.
Was there any evidence that he was having sexual relations with her?
Yes.
Where'd that come from?
She advised that they were having sexual relations at the time.
At trial?
Not at trial, but again, had this been raised, that certainly would have been brought out through her testimony at trial. Again, it wasn't relevant for our purposes since that was not raised. However, that would have become relevant and we certainly would have elicited testimony on that fact.
Defense attorney know that?
That they,
Were having sexual relations?
yes,
Okay.
I thought part of the Ginther record suggested that he wasn't sure, that never came up in his conversations with his client, that being whether or not he was capable of having an erection and having sexual gratification. I thought the defense counsel said that he didn't talk about that.
to the best of my recollection, Your Honor, I believe that they hadn't discussed whether he had feeling or not in his lower region. That was my recollection of it. But I know that Mr. White was aware that he being the defendant was romantically involved with the victim's mother. They did have an intimate relationship for a period of time.
I think the defense attorney said the defendant never raised the issue of having sex with the wife or that he couldn't have sex.
Or that he couldn't, that's.
That he
what-
couldn't
yeah,
have
that's
sex
what
with
he
her.
Couldn't have
Yeah,
sex with the girl,
Correct,
the mother.
correct.
Okay. I have nothing else.
Okay. Beyond that, Your Honor, I just a couple of other things that I wanted to just briefly address in terms of Mr. Foster's arguments. And then if there are any other questions, I'd be happy to answer them. In terms of the defenses raised at trial, I since I was the person that did try the case, I can't really see any better defense than I didn't do it. Right. And the fact that the alibi wasn't entirely complete, again, we have the fact that we have a very imaginative child that I believe that Mr. White developed that claim certainly very well in terms of what was brought out in the diary and in terms of her being the victim watching pornography. All of those things were certainly brought out during the trial. And the fact that I know that Mr. Foster had referenced the fact that she, being the victim, had spent a fair amount of time with the defendant afterwards, didn't exhibit any signs of fear of being around him, of discomfort of being around him. And the jury certainly heard all of those facts. So again, and the defendant did have a right to testify, and he did testify during the trial and was able to tell the jury about his relationship with the victim and that they got along and that he was like a father figure to her. So they did have an opportunity, and they had an opportunity to also see his physical condition and had an opportunity to hear from the victim's mother that she was a caregiver to him as well and what sorts of chores she did for him around the house. So they did know that he at least was disabled to the point where he required a chore provider and a caregiver. Trying to think of anything else. And again, as I already referenced in my written submission, Your Honor, so I'm not going to belabor the point. Pleasure, sexual gratification, that's not an element of this offense, Your Honor. So any reference to the fact that the defendant couldn't feel pleasure or experience pleasure as a result of this, I don't believe is in any way relevant. So this information certainly wouldn't have gone to that. And as far as explaining why this would happen and how this would explain that to a jury, why would he have a child do this? I don't think that sort of thing would enter the mind of a jury simply by hearing this evidence. I don't think that would be relevant either. Beyond that, Your Honors, I don't have anything further unless the court has any further questions.
You might have already said this, so I apologize, but at the time, so at the Genther hearing, you cross-examined the defendant with the MDOC medical records. Did you have those at the time of trial, or did you get those after the trial?
I got those after the trial, Judge.
Thanks.
Of course. Thank you, Your Honors.
Counsel?
Yes, a couple things with regard to the testicle removal surgery. The record would speak for itself at the Ginther hearing, but it's my understanding that Delanius did testify as to that. And he testified that it wasn't because of pain, because the doctor told him the testicle was on the inside was about the size of a pea and it was no longer useful and just needed to be removed, but it wasn't anything, a complaint of pain or any other discomfort. And I don't believe he did ever deny having that surgery, but the record would speak for itself. In terms of Ms. Hoover was saying how, you know, if this defense was going forward, she would have had all the medical records and been prepared to rebut. But if it was a trial strategy where the defendant and his attorney came up with a strategy, okay, part of your testimony is that you're going to testify that you honestly can't feel any sensation below the mid chest. And then that comes out as testimony without any medical records. There would have been no opportunity for the prosecutor to rebut this and come back with any sort of medical records at that point. Now,
That brings up the obvious question here, which is your client testified at the trial. Why didn't he work this into, you know, if this was such an important defense to him, why didn't he work this into one of his answers to one of the questions?
Well, that's an important question, Judge Wallace, and I did brief that. I cited the Ginther hearing. Um, I actually asked Delanius that question, and he said, well, I didn't want to be disruptive. I only wanted to answer the direct questions that were asked of me. I didn't want to be seen to be out of line or causing any disruption with the trial. So he did answer that clearly and openly. And I would direct you to the let's see.
Yeah, he said he didn't want to blurt out anything because he thought it might get him in trouble for speaking out of turn.
Exactly, yes. So the other thing that I briefed, I did actually submit records from the War Memorial Hospital in Sault Ste. Marie about when this would have been after the trial, but it just shows, it gives support to the fact that that Delanius had actually broken his femur when he was doing exercises. As you know, the femur is, I think it's the largest bone in the body of the thigh. And could you imagine breaking a femur and not feeling any pain? And I couldn't, but he didn't even know it was his femur. He heard a pop because his ears were working, and he thought it might have been his hip because he had a hip problem earlier. He didn't even know he broke his femur, and he was taken to the emergency room not because he felt pain, just because his body was out of whack. And if you look at those records at the ER, it says he describes feeling no pain. So I think we can look at that as very strong evidence that the truthfulness of Delanius' testimony at the Ginther hearing. Obviously, that wouldn't have been available at trial, but it shows now when you're looking at it in hindsight, was he telling the truth? Could he feel pain? We know he couldn't feel any pain below the waist when he broke his femur. So I think it's very, very important to consider when you're looking at the credibility of Delanius at the Ginther hearing, as well as the whole theory that this lack of any sensation was true and viable. And not that it would have made a reasonable difference, but whether there's a reasonable probability. I think that's the key. And if that's it, I think I'm about done, but if there's any other questions.
No questions, but I just want to say both of you did an excellent job briefing this case. Well done. Agreed.
Thank you.
Okay, that case is submitted. We're moving on to docket number 3 on the docket, which is 369421 People versus Savage.
Both are remote.
Both are remote. Okay, great.
Good morning.
Morning.
Good morning. Okay, I was getting joined in. I think you were calling the case. The case has been called, Your Honor?
Yeah, this is you're here for People v. Savage, correct?
Yes. Yes. Thank you, Your Honor. Thank you.
Okay,
Yes.
proceed. Thank you.
Yes. Thank you, Your Honors. May it please the court, Ian Kerpal on behalf of Mr. Savage. Turning to issue 1 here, lack of probable cause to search the truck. When officers arrived on the scene here, Mr. Savage was no longer in his truck. The truck had been parked and he was outside. Now, when the officers showed up,
The tow truck driver and the son both said they saw him with a gun in the truck.
yes.
Okay, does that give probable cause?
If at the time the officers had arrived, Mr. Savage was still in his truck, and everyone said Mr. Savage had never left his truck, then yes, that would be probable cause, and I would not be making this argument here. But we had a change in circumstances here, which is when the officers arrived, and we don't know how long it took for them to arrive here after the initial call. But when they arrived, the truck was parked on the side of the camper, and Mr. Savage was outside of his truck. And one of the Normans even thought when he left the truck, Mr. Savage disposed of it. And certainly when the officers arrived, they thought the same thing, right? I mean, you had Officer Newman talking about how he thought the gun was in the camper. And And at one point he said, for sure it's in the camper. You also had Officer Newman looking in fire pits. You had Officer Newman looking over a fence. One of the other officers on the body cam indicated, talking about they want to drive around to look for this gun because the thoughts that Mr. Savage may have thrown it. What's critical here, Your Honors, is the fact that by the time officers arrived, Mr. Savage had parked his truck. He was out of his truck. Pistols are very movable, and and I understand where the officers are coming from. Where's this gun at? The officers thought the gun could have been anywhere, quite honestly, and I agree with the officer's assessment at that point. The gun could have been anywhere. But it doesn't mean you have probable cause that they go ahead and search the truck. Again, when we're talking about probable cause, it must be based on some sort of objective fact and not some subjective good faith belief. Now, subjectively, could the officers believed, hey, we think the gun might be in the camper, we think the gun might be over the fence, maybe it's in the truck. Subjectively, sure. I mean, if I were to show up, I would subjectively think it potentially could be in all those places.
But objectively, they knew that the father and the son both said that they saw him with the gun in the truck.
At one time, yes. And when they arrived on scene, Mr. Savage was no longer in the truck. He was out of the truck and the truck was parked. I mean, at some point,
Right, and the weapon is nowhere else. So they actually make substantial efforts to try to locate the firearm. They're not able to. Now there's one place left that hasn't been searched. They've done everything else. Why don't they have probable cause necessary under the concepts of US v. Carroll and its progeny in the Michigan jurisprudence to be able to search the truck?
well, Your Honor, I would disagree on that they searched everywhere else but the truck. I mean, they also thought it might have been the camper. There was also another car there parked next to Mr. Savage's truck when they were on scene. There's certainly lots of other places a pistol could have been hidden. And certainly at some point, probable cause gets cut off. At a certain point, the information just becomes stale, right? He left the truck, he's out of the truck. At some point, right, the probable cause goes away. It's certainly
How
when you're
many
hearing
minutes had passed since
Yeah.
the gun was supposedly pulled on the victims and when the search was effected?
Judge, I'm not sure. I
Can
don't
we
think it was
all
less than-
agree that it was substantially less than 60 minutes?
I looked at the videos and I can't remember how long they are, but they're body cam videos from, let me see here. 4 different officers. And it says here 51:36, 51:37, 45 minutes and 35 minutes.
So if the,
It's not hours, it's not days.
yeah, I mean, I've heard the stale argument any number of times, never in a temporal situation like we had before the court.
Well, I think it's important in this situation because the pistol is a very movable object. It just is. And certainly when Mr. Savage parked,
It was a bag of crack. So is methamphetamine
Yes.
pipe. I mean, that which is searched for normally is not the size of a billboard or a Greyhound bus.
And just looking at that, from the outside, looking in that truck, there are plenty of places there where the gun could have been placed and not seen.
oh, sure. And it was in the case in the back of, behind the seats, and certainly the truck was messy.
The truck wasn't a model of cleanliness, I guess would be the polite way to put it.
No. And, Mr. Savage, some items in there, he had some marijuana in there, which perhaps is the reason he didn't want them searching his truck to begin with. But related as a whole, I mean, look, the officers didn't know where this gun was. They thought it could have been anywhere. And I think that's really what the key here is. And why not just search his truck from the get-go? Instead, they pressured Mr. Savage for consent to search his truck, and he never gave consent. It was only after.
What's wrong with that?
Right.
I
I'm really.
don't see what's wrong with that.
Nor I. I was very perplexed by that argument. I candidly do not understand it. Maybe you could help us.
Well, certainly you can ask for a consent. That's the easiest way, right? I mean, to get around the probable cause requirement, where requirement is ask for consent.
Also, saves you having to call the judge or a magistrate.
Sure. Well, sure. I mean, if they sought a search warrant against the camper, perhaps. But sure, I mean, you ask for consent because that's the easiest way to get around the constitutional requirements there.
Well,
Uh,
it is a waiver of the citizen or the person's seeking to be searched constitutional rights. It's not a getting around. It's a waiver, an affirmative waiver by the individual. He chose to exercise his rights. I
Yes,
just
he
don't.
did. Right. And it was only after that point where the officers decided, well, we need to get into his truck now. I mean, I can understand why the officers want to get inside his truck, but you still need probable cause to get inside the truck. I mean, the truck had been parked, he's out. Some time has left here. Um, but then, when one officer's talking to him, he does bring up the phrase probably had probable cause. So again, when they're trying to get consent from Mr. Savage, they talk about that's Officer Hager's body cam probably had probable cause. So again, Your Honors, I'm not convinced here that officers actually thought they had probable cause here or believed objectively they had probable cause. Maybe subjectively, maybe they had a hunch that they thought the gun was in the truck. But certainly there's no objective facts here at the
There's
time.
no objective facts, again, coming back to the father and son. They saw him in the cab of the truck with the gun. He waved it at him.
And if officers arrived and Mr. Savage was still in this truck and no one said he left this truck, I wouldn't be making this argument. I would agree with you, Judge Reardon.
Okay, I understand your argument. I
Right.
think at least I'm good.
Okay. All right. And again, as this, I think, these facts and circumstances of this, obviously at that time didn't have probable cause. Issue two, there's precedent on that one. I'll skip over that one because it's just raised for preservation issues. Issue three, I'll rest on the brief. Issue four, we have Officer Hager's body cam here where he talks to a female witness. And this female witness is critical to Mr. Savage's defense here. Because as she talks about, is Mr. Savage pulls up, gets out of his truck to start to take the lugs off. She talks about how when they were taking the lugs off, the other guys, the repo guys, almost caused an altercation. That falls in line with Mr. Savage's, excuse me, defense that he pulled up, got out of his truck, grabbed his lugs. Some of the repo guys chest bumped Mr. Berger. What she said she saw lines up with Mr. Savage saw. Now, even if she was not in the position to definitively see if there was a gun or not, certainly what she saw impeaches what the repo guys said, which is Mr. Savage pulled up, pulled the gun at us, and we retreated. She never saw a retreat. She saw the repo guys almost, I'm sorry, Judge.
Wasn't her sight obstructed? I mean, she didn't have a clear view of the cab. I watched that interview. She was across the way at another trailer.
Mm-hmm.
And she didn't have a clear view of the cab from my seeing of the video, review of the video.
Right, and maybe from her vantage point, she could see a gun or not. Obviously, we don't have, we didn't recreate the scene there to see if she could see it. But what she did see was the repo guys almost started an altercation with Mr. Savage and Mr. Berger when they tried to take the lugs off, which is contrary to what the Normans testified to at trial, which is Mr. Savage pulled the gun on us and we retreated. Completely refutes that, completely impeaches their testimony. So it would make sense in that regard. She never saw a gun. It certainly supports Mr. Savage's defense.
Was there testimony that he walked around outside the truck with the gun?
Whose testimony, Your Honor?
Is there any testimony that he was outside the truck with the gun?
No, it was always inside the truck that he allegedly pointed over the ledge and.
Right, that's what I thought, always inside.
Correct, right.
Okay.
So now the body cams are all part of People's Exhibit 3. The prosecutors sought to admit Exhibit 3. Defense counsel at trial said, well, just the parts that were shown to the jury. And I guess that was admitted. Look, this female witness would have supported Mr. Savage's defense. I don't know why trial counsel objected to it. At the get-there hearing, they mentioned detrimental information. I didn't specify what detrimental information was in there that he was worried about. Hearsay, sure, but once it's submitted, it's in. And certainly when the prosecutor sought to admit Exhibit 3, the prosecutor never said, hey, I'm going to redact this only to the parts that were played to the jury. The prosecutor sought to admit Exhibit 3 in its entirety. And I do trial work, and I've done trials and certainly, you know, I for prosecutor's seat to admit things that help me. Cool. I'm all for it. This saves time and energy for me. So critical witness there could have got that information in if he would have just said, hey, no objections to number 3 coming in. Could have talked about that female witness once it's submitted in his case in chief and closing, whatever he wanted to do. So with that, Your Honors, I will rest on the remainder of my brief, unless Your Honors have any questions. Thank you. Oh, I'll reserve 2 minutes for rebuttal if necessary. Thank you.
Mr. Sauter.
Good morning, Your Honors. Drew Sauter on behalf of the people. At this point in time, I would rely on the brief that was submitted on this particular case unless Your Honors have any questions.
I do not.
Thank you.
Okay. I suppose, there's nothing to rebut there,
Gonna
so.
say, how are you gonna rebut that?
So thank you, gentlemen. This case is submitted. You have a good day.
All right, thank you.
Thank you, you
Your
too.
Honors.
See ya.
Okay, calling number 4 on our docket, 370765, Page v. Progressive.
Good morning. May it please the court, I'm Michael Ross. I'm appearing on behalf of defendant appellant Progressive Marathon Insurance Company. We have no brief from the other side on this case, so I will be very brief. The reason we should win this appeal is that the trial court clearly got it wrong.
I personally think you're in pretty good shape.
Okay, then I'll be even more brief. I think the record is clear here that there's no genuine issue of material fact. Nothing was supported by the
Well, we don't
plaintiff.
have a Bozzi situation where it's a innocent third party who's seeking to be
Exactly.
the claimant on the policy, and yeah, it's
Unless the court has questions, then I will rest on the briefs. Thank you all.
Thank you. That case is submitted. Calling number 5 on our docket. Let me turn the page here. 372493, Hectate Energy versus Earl and Hazel Midland Trust.
Morning, may it please the court, John Moodhart on behalf of the appellants, the Midlams. They're also here today, and my co-counsel and principal trial counsel, Don Passenger, is at counsel table with me.
I thought that was Judge Passenger when he walked in, but it's good to see you, Judge.
This
I
is,
have one question for you. Why don't you just redraft the lease to exclude the area that everyone agrees should have been excluded?
is this a settlement conference?
No, I'm just, why hasn't that been done?
Yeah,
That's
I
a
think it's-
legitimate question. I don't know if that's.
Yeah, and my
comeback's
question,
legitimate.
my notes are in big letters. What is status now?
I think it's fair to say that would be, might have been something that would be a workable idea back when all of this was going on in front of the trial court. Since that time, this is not part of the record. I'll say that up front. Promises have been made to leave the trees alone in the restricted area, for example, and then a lot of them were cut down, allegedly by mistake. And my clients called the police and they came out there to stop them. And there just isn't a lot of trust here on the part of the farmers that the
President Reagan, when dealing with the former USSR, said, trust but verify.
yeah.
That's good lawyers can draft documents that accomplish that, which that great president was able to do, leading to the
I
end of
concur.
the Soviet Union.
I absolutely concur, Judge Redford, but that's what this case is about, right? This is a contract case. It involves an option that was drafted by, I think, good lawyers. And it very clearly said part of that it was the only legal description in the documents that were assigned at the beginning, right? There was no description in the form of lease attached to the option. The only legal description, the only description of the property at all said that there's a restricted area, trees in this area are to remain. And for some reason,
Is the solar farm, is it up and running and generating energy? or-
not yet. For some reason, despite the protestations of trial counsel and the defendants in the case, there was insistence on the part of the guys from Hecate to force the Midlands to sign a lease that didn't have the bargain for consideration, the restricted area that was in it. And so, I mean, in some ways, this case is even simpler, I think, Judge Redford, than you've characterized it. I mean, this is the lease that the trial court ordered signed. It doesn't have a restricted area in it. And the law in the state of Michigan, 80 years old at least, back to the LeBaron Holmes case that we cited from 1947, is that an acceptance of an option must be in strict compliance with the terms proposed by the option as to the exact thing offered. The words comply minutely with the option also appear in that case. And this just didn't happen here. I mean, this is a case, remember, this isn't a lease reformation case. This isn't a case where we're trying to figure out what the lease ought to say or shouldn't say. This is a case brought by the option holder saying, I've exercised my option and you, Judge Lipsy, need to order the Midlands to sign this lease. That's what the case was about. It's a contract case. Doesn't even rise to the level of a real estate case yet, because as the I thought I had the case name in my head, but I don't. Johnson Family Limited Partnership case says an option is not even an interest in real estate. It's a contract. And if you want to, and what it is it's an offer by the landowner to say, I'm signing this. I hereby offer to lease my property to you on the terms in this document. And in order to accept that offer, you have to present a lease that complies minutely with strict compliance with the terms proposed as to the exact thing offered. It didn't happen. And so it was error for the trial court to say that acceptance of that offer should generate that lease being signed by these people. It's really just that simple.
What happens if you're right? What happens if the appellees are right? What does the future look like if you're correct?
What does the future look like if I'm correct?
Mhm.
Well, there's a lot of, that's a difficult question to answer. I mean, but I presume it depends on what you three gentlemen decide to do. What I'm asking you to do is to remand the case for dismissal, because it's a lawsuit that says we exercised our option, make them sign the lease, and it just isn't true. They didn't exercise the option validly, and so there's no case. Now, perhaps they'll file another lawsuit. Perhaps they'll try to exercise the option again. Perhaps they'll decide that they want to offer or negotiate some sort of settlement. I don't know. So I can't answer that question with much specificity. I can say if their position prevails, okay, we have a final order that's issued by the trial court that says sign this lease, right? That is combined with two very large problems. One of which is the trial court said that it wasn't ruling on whether or not there was a restricted area in the lease. And so how do we fix that problem later without being res judicatated, if I may use that word as a verb, that term as a verb, out of our next lawsuit? When we file a lawsuit and say, okay, this wasn't decided in the first case, we want the lease reformed or something, I don't know. How do we do that? Okay, I'm not certain what that looks like. That's the first problem. The second problem is both of these documents have merger clauses in them, right? The option says, and this is.
Hold on, before you do that, wouldn't they have the same problem? If the case gets dismissed and they try to exercise the option again, aren't you just gonna argue res judicata?
I don't know what I'm going to argue at that point. I mean, candidly, Judge Wallace, I haven't really thought through that quite to that point. I've got sufficient unto the day is the evil thereof, right? It's, you know. that there are also, like I said, there are competing merger
What's
clauses.
the status of the $122,000?
The $122,000.
Wasn't your client paid $122,000 to keep the option open?
My clients were paid option payments up until the time that the trial court's order was
Total
entered.
up to about $122,000.
I think it was about $30,000, Judge. And then after that, lease payments have been made via checks that haven't just not been cash.
What's the status of whatever payments they received?
Excuse me?
Which do they still have the money?
They have the checks. They haven't cashed, they haven't negotiated the checks.
And how about the $30,000 you said they
The
received?
$30,000 were option payments that were made along the way.
Okay.
And those, for some period of months, years prior to the alleged exercise of the option. So that money's been, taken by my clients. I mean,
That's deposited and spent.
yes. Well, I don't know about the spent part, but definitely the checks have been negotiated.
They've taken ownership of the 30,000.
They have.
Okay.
And the idea, one of the things, and I did brief this, I sort of tried to brief this sort of carefully, and especially in my reply papers, that somehow the trial court litigation was about the Midlands challenging the validity of the option. And that is not what it was about. The Midlands have never challenged the validity of the option, the enforceability of the option. What the Midlands have done is said, this is a valid contract between us and the putative
I understand it
lessor.
correctly. All they want is a leaf with it blanked out for the trees to be saved.
They want to carve out the trees, right?
Yeah.
It's whatever the land is. If it's, let's call it a
Well,
10 by 10 by 10 or 10 by 10, they want to carve out 2.5 by 2.5. Can't go there, can't lay your pipeline through it, can't lay your electrical wires through it, can't lay your solar panels. Leave it alone. It's our historic old growth forest. My great granddad planted the first one, whatever it is. And I don't mean
all
any
of the stuff
disrespect
that's
to
in
them,
Lisa
but-
Midland's affidavit that I quoted in my reply brief. And I guess what we are not here for, though, is for this court to try to accomplish that at this point in
Yeah,
time.
we can't do anything
Yeah,
about that
we're-
anyway.
I
But I
mean,
mean, I-
perhaps Judge Redford, that will be a resolution down the road that may occur. I mean, I'm not here to settle the case.
Going back to what I said originally, and Judge Redford followed up with, it's all about the carve out. So this whole case is about the carve out.
It was at the time the case was filed, but since then, a
Thinking
lot
about other
of things have happened that have, made it more, I will just say this, I can't predict the future. I don't know what's going to happen down the road. But it's made it a lot more difficult for these parties to talk to each other, that one of them has sued the other and forced them to sign a lease that doesn't have the protection of these precious trees in it that are very important to my clients. That has done a lot of damage to the business relationship that may or may not be able to be repaired. I don't know. I'm in favor of it. I like settling cases. You guys see me here from time to time. I litigate. I also settle. I believe in it. I believe in mediation. I believe in resolution. But I mean, we can't do that
We used to
here.
have a mediation office, Court of Appeals. We don't
You
have it
did.
anymore. Yeah.
We
You
have
did.
the authority to order it under the court rules. I don't think that this is a case that's jumps out that we should order it because everybody's not getting along.
But where would we send it to? If we did order it?
Well, we do still have one. We just don't have our own mediators.
Yeah, I thought we
I've
actually-
been on one panel that we ordered it and we gave the litigants, it was with Judge Kelly and Judge Karen Ford Hood, God rest her soul. Such a fine judge. But the three of us agreed, it was the first 7 years ago, it was the first year I was on the court, on this court. And we issued an order. We gave them either 15 or 30 days to select a mediator and told them if you don't select one, we will. And lawyers wanting to make decisions for themselves as opposed to judges deciding for them. Shockingly, that they of course immediately picked somebody. Unfortunately, it didn't resolve the case, but it's, I've done it once.
I do recall that program. I do recall engaging in that program. Didn't settle that particular
We
case.
had an
but-
office. When I started here, we actually had a mediation office.
Wow.
Yeah, yeah.
And I think it's.
Sixth Circuit does, the US Sixth Circuit.
I mean, I think it's an excellent idea. I mean, I don't know, we're talking about this during, an argument of a case, but I think it's an excellent idea. Mediation, I'm a mediator, I'm a trained mediator myself. It's a great system, but I will say that once we get to this point where we're in front of you guys, it makes it's less likely that it's going to be successful, but I mean, it's always possible.
What you're saying should have been attached to that lease was the property description and the photograph that
depicts that the restricted area, correct?
Yes. But I mean, even just to return to home base with this, what should have happened is that the trial court should have said, this is not a proper exercise of this option.
Because
Right.
it didn't
And
have those attachments.
because it is not, because it does not, as required by Michigan case law, it is not in strict compliance with the terms proposed by the option as to the exact thing offered. The exact thing offered being this land with this restricted area carved out of it. Okay. It does not comply minutely. And these are not my words. These are the words of the Michigan Supreme Court with the offer, with the option.
Right. And your position is that unlike a whole other genus of contract law where substantial compliance might very well carry the day.
Yes.
When your option is in a contract for an option, it must be exact.
It must
And
be
your
exact.
position is they didn't meet it. So you
And this
gotta-
isn't even close, Judge Redford. I mean, this is a situation where you and I have a deal and I want to buy 5 gold bars from you for
So long as I don't have to
$100,000.
buy them from Passenger, because I used to serve in the same building
I
with that
wouldn't,
guy. so
you
I'd
got to be
very
careful around that guy.
there.
I agree.
He is an Eagle Scout though. So
Well, he was.
no, once,
What
What, did they
always.
revoke
He
it?
is always an Eagle Scout. Anyway,
I-
we understand your position.
Yeah,
I certainly do.
I understand I understand what.
Yeah, and so I mean, at the very best, I think we need to go back and start this over because we can't, there hasn't been a proper exercise of the option. The only other issue that I have on my list here, and I want to make sure that I don't leave it out if you gentlemen would like me to argue about it, is the idea that this was raised for the first time on reconsideration. That argument was made. That is not true. And I briefed this carefully in my reply brief. The trial counsel, brother trial counsel, raised specifically all these things about how this restricted area wasn't in the proposed lease. I quoted the affidavit. I think Judge Redford, you're familiar with it from the reply brief of Elisa Midlam about how important these trees were, how that was a material term of the option, very important. And if it's not in the lease, that's why we decided not to sign it. And that's why the trial court shouldn't have ordered them to sign it. So that's the first thing. It is not true that this was raised for the first time on reconsideration. I guess it's possible maybe that the LeBaron Holmes case was cited for the first time in reconsideration, but the absence of the restricted area from the option has been the issue in this case from the get-go. I mean, the Applebee's brief, footnote 5, talks about the original briefing in the case. And they say there was a debate in the original briefing over whether the restricted area was incorporated into the terms of the lease agreement. So this is a messy mess, and Judge Reardon, I was getting to that with you, but
I'm a messy mess?
no. Well,
You've been talking to my wife?
Judge Reardon, do not.
This is my second month in a row on oral argument with Judge Reardon. I'll stipulate to that on the record.
Do not tempt me, Judge Reardon. Do not.
Oh, my goodness.
Now, this
I
case,
know where your office is, brother.
I know you do. This case is a messy mess because there are 2 merger clauses, one in the option and one in the lease, and each one of them says the other one doesn't count. And to boot, we've got a final order from the trial court that says this case is over with. I haven't ruled on whether there is or is not a restricted area, but go forth and build your project. And y'all can't fix this other than, this is my argument, and this is what we're asking you to do. Y'all can't fix this in any way other than simply to just remand this for dismissal, and then we'll start over and see if we can get it right next time. But ordering these people to sign this lease based on this option is simply, and your review's de novo too, so this is real easy. I mean, it's contrary to well-established axiomatic Supreme Court precedent in this state, and it cannot be allowed to stand. The other reason, just to get back to it, this will be the last thing I say unless you have questions, is that we cited case law to the effect that even if it were raised for the first time in reconsideration, it wasn't, that it can still be considered by this court if one of 3 things apply.
Yeah, that dog is not going to hunt. If it wasn't raised, it's probably not going to be addressed by us. We know what the law is in that case. If requirements of justice, but
If all the facts are in the
we are a
record.
corrective court. We
Yep.
are to, and if the parties have not given the trial court the opportunity in the first instance, then I feel quite strongly. I don't presume to speak for anybody but myself, but if
Yeah.
it hasn't been raised, then
It was not, I've provided the law, you're familiar with it, and I've also provided the facts to make it very clear that it was raised way before the reconsideration motion was filed. Some additional law was thrown in a motion for reconsideration. That's it. Same law that I'm citing to you today, along with the same facts that were cited to begin with. So unless there are questions,
Thank you.
thank you very much.
Good morning, Your Honors, and may it please the court. My name is Edward Moss. I'm from Cahill Gordon, and I'm here for the plaintiff appellee Hecate. So I think the first question out of the gate was the exact right question. Why don't the parties just sign a lease that has the restricted area?
I don't think that was the first question, but go ahead.
I think it was.
Oh, wasn't?
yes.
Okay, fine.
Sorry,
Go back and look at
Judge.
the video.
Sorry if I misspoke, Judge.
No,
Redford, but
apparently you didn't.
that was my understanding. So the answer is, I don't know. Because although I think there are good and sufficient arguments for why the lease does not have to include the restricted area, and I will get to that, we've already caved on this issue. We said that there's a separate proceeding in federal court where we have sued to enforce the lease agreement, and we won a preliminary injunction there. We represented on the record, I told Judge Beckering, we will agree to reform the lease, to exercise the option with a new lease that includes the restricted area.
Have you provided in writing a proposed amendment to the
Yes.
lease? In addition to that, whatever amount of consideration you're going to provide to them in exchange for the loss of whatever trees were removed. Have you done both of those things?
We have sent them the new lease, which includes the restricted area.
Right, which you already have taken trees out of, correct? And whoever's speaking in the public area, if you cannot maintain yourself and not speak, while this is an emotional case for you, it is an argument and for the lawyers, it is not the time for the public to comment from the public seating area. And if you cannot stay silent, I would respectfully suggest you might need to go outside and wait until the case is done. It is not appropriate for members of the public to be making comments. That's the second time it's happened in this oral argument from the same general part of the courtroom. And I know I would appreciate it. And I apologize, PJ, for jumping on your bandwagon, but it is not appropriate for members of the public or anyone to comment from the gallery. That's not how we proceed in the Court of Appeals.
So, Your Honor, we have provided the new lease. We have not provided an offer for the consideration. What we've done, and I just want to clarify the issue with the trees. All of the conversation has been that we were going to build a transmission line through the trees. And what we did was we spent hundreds of thousands of dollars on our dime to come up with a plan that would bore under the trees, that would put the transmission line under and would not disturb any of the trees. There was a mistake, frankly, and we put this in the affidavit in the federal court proceeding. It was inadvertent. It was about, I think, 0.2% of the trees that
Right.
were
Well,
gone.
I'm a third
and we'll pay for
generation
it.
owner of some land in this great state. My grandchildren have been there. So now I have 5 generations. My family have been on this plot of land in northern Michigan. And there are a bunch of trees on those 200 plus acres that are very important to my family, to the members of our club. So it may not mean as much to a commercial processor, but and whether it's inadvertence or intentional, it's not what was agreed to, perhaps. And people can have very, very strong feelings about those things.
We understand, Your Honor, and that is why we, instead of fighting about this, we decided to go under the trees. We apologize for what happened, and we are willing to compensate them for what happened. I understand exactly what you're
This is all
saying.
great. You're telling us this. Why don't you tell the other side? We wouldn't even be here.
We have told the other side. We've
So
we've
we
sent
have to
them the lease
decide what to
agreement.
do now. And
So if I can move through that, I think I think the
Why do
point,
you think the option that was provided to the other side of this case was identical to the option that they agreed to?
so I don't think that it was identical to the
And if
option
it
that they
wasn't,
agreed to.
how are you entitled to the injunctive relief that you received? How is it not a mistake of law that has to be sent back?
Well, Your Honor, because I think the point is
Fact, mistake of fact, thank you.
that argument was not actually raised down below. If you actually look at the briefing down below,
I kind of buy into the manifest injustice if it wasn't, but I think it was raised below. Yeah, I just don't see.
Raised
when I-
on the first page.
when I-
Right? I mean, what do you think they're saying? I mean, they're saying this contract isn't what we agreed to. If that
well-
doesn't buy, the negative pregnant of that must be that the option area, which was described, is not included. I mean, it's.
When I
I
first
think
read
the
this-
argument was,
When I first read this case, I thought, what are they doing here?
Right.
What are we wasting our time for?
Well-
It seems to me there was a big boo-boo down below.
well, I do think that the argument was not raised before. I think that the argument that they were making down below was that the lease agreement should have included the restricted area. They were not making the argument that we did not exercise the option according to its terms. So it's actually a different argument that they were raising, and there,
You agree, counsel, that whatever it is that was provided to the landowner who owns in fee simple this property in the 26th state of the union, where your client said, we will use A, B, and C, we will pay you X number of dollars. In exchange, this is what we're going to do, and we promise we're going to leave this section alone. Because, okay, we agree that that's the first part, correct?
correct.
In the second part, your client then provides a contract that says, we're exercising the option, sign here, we're going to do this. But it has no reference to the holdback provision of the section of land, which they have specifically said you cannot touch, develop, or go on. Do we agree with that?
We agree with that, although I
Then
do
why-
think there's,
How is there possibly a lawful exercise of an option under the Supreme Court jurisprudence of the state of Michigan?
I think that there's an ambiguity in the option agreement and the lease agreement, because the lease agreement
Who
included.
does an ambiguity get considered in favor or against? Under Michigan law and virtually the jurisprudence of the entire nation.
It's the drafter, of
And
course,
who
but
drafted this document?
I think the parties drafted it
Which
together, and
parties drafted this document?
I believe that there's a provision in the contract that says it shall not be construed against either one. I'm not sure about that,
I'd
Your
have
Honor,
to
but
find, I'd have to look at that. I'm not so
yeah,
sure.
I'm not sure
Yeah.
whether there.
But
there
that's a
is or
good
isn't.
comeback anyway.
I'm not sure. Well, I'm admitting I'm not sure whether or not there is or isn't. But I think the point here is that this was not raised below. It would not result in a manifest injustice because we are willing, and the question that one of the judges had about what would happen either way, we're still within the option period, and we would exercise the option
You
with
guys,
the
as far as I'm
reform
concerned,
lease.
You guys can work it out, but we'll have to make our decision here.
All right. Does anyone have
I
further
don't have any
questions?
questions.
Thank you.
Thank you.
Thank you.
Thank you.
I know you don't want to hear much more, but just a couple of things need to be corrected. This whole agreement to reform the lease obviously is outside the record, but that probably didn't even need to say that. We have not received a proposed lease amendment. We've received an email. There's no proposal for the replacement of the trees. The hundreds of thousands of dollars that were spent are hundreds of thousands of dollars that were spent apparently to comply with what the original option was supposed to require, that the tenant decided initially to instead sue us and force us to sign a lease that didn't require them to spend those hundreds of thousands of dollars. The other thing I would say is that those hundreds of thousands of dollars are spent to bore underneath the trees for the transmission line, which may or may not damage the trees, but it certainly isn't in compliance with a carve out of that area or leaving that area
I
alone.
know we have another case about boring under the Straits of Mackinac. I think Judge Wallace has familiarity with boring, so that could be helpful, but go ahead.
And to do this instead of fighting is what Brother Counsel said. There was a lot of fighting in the trial court. And my clients lost, and that's why we're here. The final thing I would say, if there are really ambiguities, it's the first time this argument's been, talk about things that have come up for the first time in the appeal. That's a new one. But if there's an ambiguity, I would have to research it too, Judge Reardon. But what I am certain of is that if there's ambiguities in the lease and in the option agreement, summary disposition should not be entered. Unless there are questions.
Any
That's my
questions?
argument.
No
Comments?
questions.
Thank you.
I have a couple of comments, if I may, PJ.
Sure.
Counsel, Judge Pastor knows I had the privilege of serving as a circuit judge for 12 years, and most of that in the same building he was in Kent County. I had 10,000 cases assigned to me. I was also a judge in the Navy and Marine Corps trial judiciary for 5 years, tried cases all over the world for the Navy and the Marine Corps team. Why am I talking about that? Because after 10,000 cases, 4,000 of them civil in nature, I steadfastly came away with the belief that a bad settlement is better than a good verdict. And when you reach a bad settlement, it means both sides compromise. Nobody can grow back the 100 or 50 or 150-year-old trees that have been cut down. Just can't happen. Nobody can set the time back, the 24 months lost on the solar field and solar panel field development. Nobody can change that for either side. What you all can do is control your own destiny. And that is, forget about the past. We're going to make a ruling, whatever will happen then. But as opposed to 3 judges or 7 judges on the Supreme Court or a trial judge figuring it out, this case to me, and I say this probably twice a year in oral argument, this is one of these cases. And maybe I'm more in tune to it because after case call is done tomorrow, I'm staying here in Lansing to serve as a mediator in a case between parties pursuant to some other case law and cases. So settlements are on my mind right now. You need to work this out. I mean, no matter what solution, whoever wins, nobody is going to be satisfied, and everybody's going to keep fighting about this. There's probably a beautiful piece of land that's been in a family for generations. There's probably a wonderful project that's going to have environmentally smart energy. Both can peacefully coexist, but it's not going to happen because of what we say. Work through it is my urge and suggestion. You're going to get an opinion from us at some point in the future. Don't let whatever we say control your future. You control your own futures, I urge you to think about. If anybody objects to that, take it up with the Judicial Tenure Commission. I'm pretty sure I'm allowed to make those comments, but if anybody wants to correct
Oh,
me.
you didn't tell them to hug each other.
I'm
So
not,
that's,
nobody's going to hug each other, okay? We're not going to be trading Christmas cards here. But you can have peaceful coexistence. And again, I said, I'm a 3rd generation property owner. I get the whole tree thing. Believe me, as I walk through my forest land after a forestry group went through, I understand it can be very emotionally draining, but it doesn't make the tree stand up again. Just get to a good solution that works for everybody would be my respectful suggestion. Thank you, Chief, for letting me say that.
Thank you. And that matter is submitted. We're now moving on to number 6 on our docket. Number 6 is case number 370867, L's versus L's. We'll give these folks a moment to file out. Okay, counsel, please proceed.
Good morning, Your Honors. Elizabeth Parker, appearing on behalf of the appellant Andrea Els. May it please the court, I would like to reserve 5 minutes for rebuttal. And before I move into my argument, I would simply reflect on Judge Redford's statement. I actually did have 2 cases that the Court of Appeals has sent into the mediation program. And it exactly as you outlined, we are directed to pick someone and agree on someone. And one resolved and one is still in process. So I think, you know, from my experience, the court's been pretty good about figuring out which ones might benefit from that. And
Thank you for sharing that.
It's an interesting process coming from the appellate side as opposed to doing it in the trial court.
Right.
But sometimes you bring a little more distance and you can pull some of the emotion out of it as well. Moving on to the case at hand, I would principally, I'm going to rely on my briefing, but I would like to address just briefly 2 points. The trial court concluded that Andrea Els had been willfully absent for at least 1 year prior to Donald Els' death. I would argue that that is contrary to the Supreme Court's ruling in the estate of Von Grief, where the Supreme Court there adopted a rebuttable presumption that one is not willfully absent from the marriage when they're undergoing divorce proceedings, as that action in and of itself acknowledges the existence of the marriage. And if we look at the facts of the Els marriage and compare it to those in the Von Grief matter, they parallel. There was a time
When
period
did the divorce proceedings, when were they initiated?
in Els,
Yeah.
it was in 22,
And she left-
2022.
She left in 2020.
Correct, correct.
So we got 2 years right there.
Well, in Von Grief, they lived apart for a significant period of time as well. And I don't think in the context of a divorce that that's unusual. People reach their point where they say, we're going to divorce. And oftentimes people do. If one person moves out, they start to build their own life.
How about if divorce isn't discussed, they just say, I don't want to have anything to do with you anymore. I'm done with you. I leave. And then the clock starts again if you wait 5 years and file for a divorce? Is that what you're arguing?
Not at all. Not arguing that at all. What I am arguing is that we have to look at the circumstances of each case, which is what I believe the Michigan Supreme Court told us when it created the rebuttable presumption. And when we look into the facts of this case, what we see are 2 people who had, by all accounts, a very rocky marriage, times where she left and came back, and her testimony was that some of those times it was at his direction. He told her to leave. And so she did. And what we have, however, is that during those times, they kept communicating. There were times where they would get back together. There were times when they ultimately started talking about divorce and talking about trying to reach a resolution of the marital estate. When they ultimately weren't able to reach that through themselves, they both retained counsel and they filed the divorce proceeding, and they both made claims towards them about the marital estate.
You know, going back to Von Grief, wasn't the look back period in Von Grief encompassed entirely by the period from when the divorce proceedings were initiated? We have a different situation here.
Well, I guess it depends on when you are starting the look back period. If the look back starts from the date of death, then here the date of death was December of 2023. The divorce proceedings were pending during that entire time.
Yeah, but they were, she left the house or they were separated, whatever you want to call it, from 2020.
Correct. And in Von
So
Grief,
that's going back 3 years. Von Grief, the entire period was encapsulated from the divorce proceedings forward once the divorce was initiated.
that is true. But I don't
Okay.
think, I think the
Different
point of,
situation here.
I'm
She was
sorry?
gone- She was gone for a few years before the divorce, a couple of years anyway, before the divorce proceedings were initiated.
That is correct.
All
That is
right,
correct.
so I'm just trying to,
So is there any
I'm
point?
just
at
trying to
which-
reconcile this with
Yeah.
Von Grief.
Yeah.
That's all I'm
Certainly.
trying to do.
And
if
that's
I could
what I'm
just
trying
add
to
on
do.
a thought I've been having is if you're in a state of estrangement for, let's say, 5 years, you know, to quote from the last case, not exchanging Christmas cards, you know, whatever, in all seriousness, so there's no relationship any longer. And then finally, someone decides, okay, I'm going to change my estate plan. I'm going to talk to my lawyer and I'm going to go through the divorce. But you did it 5 years later. You file, does that then automatically restart this Von Grief clock? That's my question. Because it sounds like your argument suggests that it does.
No, I am not arguing that. I'm definitely not arguing. What I am arguing is that you have to look at the circumstances of that relationship. I don't think that the static facts of when did you move out, when did you file, are the controlling elements at all. I think what Von Grief tells us is that we look at the relationship between the parties and what was happening during that time. And so what was happening during that time in this case is they were still having communications. They were she was giving him assistance on paying bills.
According to the trial court, that it was undisputed from at least April 2021 that she moved out to her own condo with her personal belongings and ceased contributing to Donald's bills or other debts.
Well, and that
That's
would
the
bring
trial
me-
court's finding, not ours.
I agree with you that is, and that it would actually bring me to the second point I wanted to make. That trial court finding was based, I believe, on inadmissible hearsay. We had testimony coming in from the decedent's daughters who said, well, my dad told me this. Classic hearsay. They weren't coming in, they weren't statements coming in about a state of mind. They were a statement of memory or belief to prove a fact. And that is exactly what we're not allowed to do under MRE 8033. And so I would argue that the trial court erred in allowing that testimony to come in and basing her decision on that. The testimony that.
If it were admissible, would it have been an appropriate finding?
I think it could have been an appropriate factual finding. However, I think it has to be viewed in light of the entirety of the case, including the actions of Donald Els. We can't forget that during the time that the divorce was pending, he was arguing that there was a marital estate to be divided, and he was making claims against that from assets that were in her control and possession. And so the idea that he used his estate plan as a quick substitute for a divorce, I mean, that's what we're going to end up having, is that someone makes an estate plan and says, haha, I disinherited you, and so now you don't get anything. They were both making claims against what they believed to be the marital estate. That is acknowledging the existence of a marriage. Maybe not a good one, and certainly not one that any of us would hope to be involved in, but that's what Von Grief talks about, is something that acknowledges the existence of the marriage beyond the bare existence of the separation and the divorce. You need to look at what that relationship is between the parties. If we look at Von Grief, for example, they had literally no contact whatsoever. And while they had the divorce proceedings going on, he was ill. She had no contact with him whatsoever. She had established her own home. She had moved on. Very similar circumstances here.
She
The
filed for
time-
divorce like 2 weeks after she moved out.
Right. And in this case.
In this case, we've got how many years?
It's roughly a year and a half, I would say, year and some months. But the difference, which I think is not inconsistent with Von Grief, is that they were having discussions trying to resolve things themselves. And there was evidence introduced to that they were talking about how to split up the marital estate and who's taking what and who's doing what and who's paying what bills. And then finally, the testimony was he decided to go ahead and file, which was consistent with the discussions that they'd had when she moved out. His representation was, I'm going to file. And she said in her mind, she understood that he was filing and that the discussions that they were having were essentially part of that divorce action. You know, whether or not there was a formal filing or not, there was a separation that was taking place. And the process was one that they were initially undergoing together informally and then later formally. I would finally simply point out that I believe the trial court erred in finding that Andrea was engaging in a bigamous relationship. I think the statute's pretty clear that that is not an alternate ground upon which the petition to reject her spousal status could be affirmed. And with that, unless there are any questions, I would reserve my time.
No questions. Thank you.
Thank you.
Good morning or afternoon, your honors. May it please the court. My name is Gregory Hodge. On behalf of the estate of Donald Els, I'm accompanied by my co-counsel Brittany Van Dam. We're attorneys with the Elder Law Firm. Our arguments have been made in the brief, but to point out some relevant facts as well as to respond to some things that were said in the appellant's presentation of the case. There are some distinguishable facts between this case and Von Grief. And I think when we look at the legal standards themselves as established by Von Grief, They actually got rid of a rule saying divorce just precludes this statute. It said it does provide strong favor. However, the argument that we presented is that the statute was already met a year and a half prior, to the date of the divorce being filed. There was a lot of arguments about her leaving in 2020 or 2021, but I think it's undisputed when she bought a condo, secured a mortgage, took all her stuff and left the house April of 21, she left. 12 months from there is April of 22. We're a year out, the statute is in effect. And to, say in August, when he finally decided to assert his rights, so another distinguishing fact from Von Grief is the decedent is the one that filed. And when he filed for divorce, he said there is no property to dispute. She's got her stuff, I've got my stuff. He just wanted a divorce. It wasn't until that point that she actually stepped up and said, oh, no, I think I should get half of your things. And in response to her, the appellant's statement that they were making claims against each other, the only claim that he was making is if she's going to get half my stuff, then she needed to contribute to all the things that I paid over all those years. And if anything, that amount of money should be paid back or considered in. There weren't resolutions or agreements proposed or come up through any of the divorce proceedings. There weren't any memorable or conversations other than this one conversation that existed in February of 22 after I helped him do his estate plan. He called her and said, hey, I did my estate plan. That right there, the court said, the fact that she didn't follow up on that is further evidence that she's walking away from any claims or any rights that she has. And by April of 22, that statute being met, the whole point of the statute is to give some protections to spouses who are abandoned. In response to the hearsay allegations, the best response that I can share is that the appellant herself is the one who admitted all of the facts that the judge and the court used in its ruling, which is the mortgage and condo, the move out in April. She quit paying household bills and marital debts. In the transcript, she admits those things. She admits to the phone call and being told that she was not, that there was an estate plan. She even goes on to say that she knew that she was not an agent in that estate plan. She admits to a romantic relationship, coincidentally starting in the same month that the individual died. There wasn't a lot of digging into that. I don't think the bigamy point of the appellant's brief matches up with what the judge was saying in her order, which was it could have been this, but there obviously wasn't any evidence to prove bigamy. There was, however, evidence to prove that there was an inconsistency with this spouse and her belief that a marital relationship still existed in the fact that she admitted that she was in a romantic relationship, even if it was in that last month. I think at this point, I want to pause for a minute to see if you have questions, because I can rattle on and talk for the next 20 minutes, but I know.
Apparent.
Huh?
It's apparent.
Sorry, Your Honor.
I have no questions.
I don't have any other questions.
Lord, I prepared all this good stuff for you guys, but I do believe the brief says it all, and I just wanted to make sure to respond to those major things that were said. This case is definitely distinguishable from Von Grief, and I pray that
It's
Your
certainly
Honors.
interesting.
It is, and it gives the court an opportunity to make a ruling based on facts beyond a 13-month window. And I think that was something that Von Grief really made hard in this decision. So looking at all the facts as admitted and looking past.
Do you think it makes a difference? The appellant removed herself from the marital home some substantial period of time before the filing of divorce. Is that of any moment for us?
I believe that that is relevant in proving that the statute is met. She removed herself from you mean she removed herself from the home when she bought the condo and?
Right.
Yeah, I mean, that really.
On her own, she's the only one on the encumbrance to the deed. The decedent has no interest in that.
I believe those facts prove the case that she willingly absented herself. And what I was surprised.
How long before did that happen? Before the divorce papers were filed?
Yeah, so that happened April 21st, and the divorce papers were filed at the end of August of 22, so
So
roughly
April
17 months.
of 2021.
Yep.
And then in August of 2022, the decedent files for divorce.
Yep.
Okay, thank you.
Thank you. I would just add on 16 months later is when he died. And
I don't want you to get me wrong. You're doing a fine job.
thank you, Your Honor, and I thank the court for allowing me the opportunity to present this.
Thank you.
Just briefly, one point I wanted to make, the comment was, when did she remove herself?
Yes.
She did so at his direction, and the testimony was clear about that. And so I think, again, that's part of those overall circumstances that we need to take into account. Thank you.
Thank
Thank
you.
you.
Thank you.
Okay, that case is submitted and we're going to take a brief recess.
Have a good day. I'll argue.
Honorable Court of Appeals for the State of Michigan, now in session, so you can sit.
Okay, calling number 7 on the docket, 368-903 Green Oak Charter Township versus DD&G Holdings.
When I came out, I looked over, I thought to myself, I thought you were gone.
Deja vu. all over.
Yeah.
No, I thought so too. And good afternoon now, Your Honors, Elizabeth Parker appearing on behalf of the appellants. I would like to address, again, two quick points and otherwise substantially rely on the briefing. The first issue I would like to talk about a little bit is latches. The trial court erred in concluding that a defense of latches couldn't be invoked when the statute of limitations had not expired. Respectfully, it works the opposite way. Rarely would you need to invoke latches if you had a complete defense on the statute of limitations. So latches is invoked when you can't win on the strict application of the statute of limitations, but other circumstances make reliance on its non-expiration inequitable. Here, I would argue that the appellants bought the property in 2008, at which point a year-round greenhouse was in operation, and accepting the trial court's conclusion that as of 1979, when there was a lot split, that a year-round commercial greenhouse was no longer a permitted use. It's uncontested the appellee took no steps to end that use between 1979 and 2008 before the appellants made their purchase, despite the obvious presence of a viable ongoing business. Moreover, even in 2010, when the appellee asked the appellants to remove a different non-conforming structure, which the appellants did, those ongoing business operations with the additional greenhouse structure was not questioned. I would argue that the delay from at least 1979 for more than 30 years is in exactly what the doctrine of latches is intended to apply to, and that the court could remand for the lower court to consider the doctrine of latches on its facts, as opposed to finding that it was inapplicable as a matter of law. The second point I'd like to make, and this ties into the motion for remand that was filed earlier in the case, which was denied without prejudice for this court to consider a remand to allow factual development. Accepting again the trial court's ruling on its face that requires the appellants to restore the property to its condition in 1967, there's no adequate factual evidence to determine what that condition and use was in 1967. And I think the use is what is really critical here. As to use, the photographs simply don't show that. They only show structures. And nevertheless, the trial court concluded that the use was a temporary seasonal structure. Appellants contend that there is evidence that would show that it had always been a year-round ongoing operation as of 1967. And the photographs that were relied on by the trial court just didn't dispute that. They just don't speak to it. You can't tell what that use is. That's just a snapshot in time. So we would argue that a remand is necessary to permit the development of evidence on that point, so that minimally if the trial court's order is affirmed, there is a factual basis upon which we can determine what does it mean to return it to its state in 1967. We're not matching a photograph, we're
Counsel,
matching
I'm
use
a
as
little
well.
Perplexed on that, because wouldn't that then require anytime that the trial court were to find a violation of a zoning ordinance by a nuisance, the is, you know, assessed by the zoning agency or the municipality. The court says, yep, there's a nuisance, you have to abate it. I'm just not familiar with any body of case law which says, and then the trial court has to make a specific determination and advisement to the parties of what that abatement looks like. I'm not familiar with that.
Well, in some sense, the court did that by saying you have to return it to its condition in 1967, but
Okay,
then
yeah,
just
I am,
left that
I am familiar with
undefined.
that, but I'm not familiar with the next step that you're seeking.
Mhm.
I've just never heard of or seen that, and I don't,
And it
why
may
do you
be,
think that's necessary?
because I think really what's at issue here is not so much the physical structures. We do have a photograph to tell us what those physical structures were. The real contention here is the use. And the use would have been a legal non-conforming use in 1967 as a year-round greenhouse operation. I believe you will hear that the appellee's position is that it was never a year-round use, that it was only a temporary seasonal structure. But if it was in 67, then that's what my clients get to go back to by the trial court's own order. And so I agree with you that I don't think in general that type of a situation would necessarily arise, because probably those are circumstances that are pretty specific and pretty easy to acknowledge or determine. I think we have a case here where the nature of the evidence really didn't speak to the use that was permitted in 67. And certainly the trial court's order didn't encompass that specific finding. And so for that reason, we would argue a remand would be appropriate under those circumstances. Unless there are any questions, I would rely on the briefing otherwise. Thank you, Your Honors.
Good morning, Your Honors. Matthew Zaleski on behalf of the appellee Green Oak Charter Township. I too will largely rely on the brief. As Your Honors know, this is a case that doesn't necessarily have a lot in the way of adventurous legal analysis. It really is about the evidentiary record. In terms of the latches argument that the appellants raise, we hold firm on the Fraser v. Haney case. The cases on latches that were cited, particularly in the reply brief, predate Fraser v. Haney. The Supreme Court is very clear that every single day that a nuisance exists, the statute of limitations begins anew.
Right, but okay, everybody understands that, but why, if the municipality had the opportunity to correct the quote problem, close quote, 15 years earlier, 20, 30, 50 years earlier, and didn't, whether or not the statute of limitations is run, why is that of any moment?
Well, thank you. The best, most honest answer I have for you to why there wasn't particularly much happening in the 80s or the 90s, change of administrations, change of priorities. But once the current administration came in, they became more attuned to these types of issues. I'm not sure
Okay,
if that
but how
answers-
come that doesn't, do you think the failure of the statute of limitations being violated, so there's no violation of the statute of limitations because it's an ongoing, every day is a new violation. Does that mean latches can never apply?
Your Honor, I would say no. I would say that the statute of limitations, if it's still running, should be honored and be allowed to apply.
Okay, so my question, I'm not being very clear, and I apologize, counsel. So you have the statute of limitations is one defense to an action under C7. Latches is another defense under C7, right? I think it's C7. I mean, Judge will also know. And then, but you could have one or either or both, couldn't you?
Yes, I can see that.
Okay,
Your
so
Honor.
if the plaintiff can demonstrate, or not the plaintiff, if the property owner can demonstrate, hey, they've been in here a bunch of times. They never told us this was a problem. Now we've invested all this money. We've made these capital improvements. This municipality shouldn't be allowed to do this.
Well, Your Honor, I think with respect particularly to this owner and this appellant, the evidence, especially the photographic evidence, does show that since the time that they acquired the property, the scope did expand substantially. So, it's not just that it was whatever use was existing in, 1979 or 67 was there. It did increasingly grow. So
Okay,
as the township.
But do you agree as a principle, they're not current in this case. The facts of this case don't support it, but potentially it could be there.
Yes.
All right.
But yes, so, in this case, I don't believe there is the prejudice, particularly since, the appellants came for that zoning variance, were denied in 08, and yet they're still continuing to, they were ebbing and flowing with the enforcement process, in some cases making corrections, but then you're restoring especially some of the seasonal storage and such. There's quite a bit that the appellants really don't even argue about. For example, the vast scope of the landscaping business portion of the site. That's not in the aerials from 1967. That's not in the aerials from 1979. That is a much more recent phenomenon, at least recent relative to the start date of this case many years ago. Likewise, the junk storage, the storage in the setbacks, the parking lot that is not in compliance with the zoning ordinance and not ADA accessible. I punctuate the fact, as I note in the brief, that it is the appellant's burden in this case to prove the non-conforming use. And plaintiff wants to go back, or excuse me, the defendants want to go back and I don't know if they want to reopen the record or have more evidentiary findings. This was a summary disposition determination. Their opportunity to present the evidence that they had was in response to the affidavit of Deborah McKenzie, the multiple affidavits, the verified complaint, the photographic evidence. Where were the permits? Where were the certificates of occupancy? Where are special use approvals? They don't have any of it. The planning and zoning administrator attested that it does not exist. And of course, it's hard to prove a negative. When the documents aren't there, they aren't there. But that's the evidence that we proposed, and the defendants' appellants did not rebut, and the trial court was correct to identify that. Just because a building was there or a use was there does not mean that it was lawful, particularly at the time that these appellants purchased the property in 2008. Yes, there could be a nonconformity on the property, but was it lawful? The appellants did not establish that in the trial court. And then as for the motion to remand issue, basically I've said what I wanted to say in the brief, but every piece of proffered evidence that the appellants are pointing to could have been available, should have been available to the appellants during the 5 years that this case was proceeding in the trial court, including that interesting email that was included, that was presented to Mr. Graves during the pendency of the motion for summary disposition. So this is not an issue of the trial court ignoring some sort of evidence that was in the record or that was presented in response to the affidavits and verified complaint. This is evidence that the defendants, forgive me, I'm very rarely the plaintiff when I'm with a municipality. That the defendants did not.
GPS to get you back to your chair.
Exactly. It's just a matter of evidence that was not presented by the defendants. And frankly, the materials that are proffered here that they're using to support the motion to remand, we submit would not change any outcome here. We're not counting cacti, succulents, and snapdragons. We're looking at the built environment of the facility, which the trial court correctly ruled should go back to the roadside stand, seasonal sales, and farmhouse from 1967, and we would ask that the trial court be affirmed.
And we agree, though, that in the opinion, the trial court more or less incorrectly cited to Tenneco. Like, in other words, the trial court cites to Tenneco and says Latch's argument will rarely succeed in bringing a claim where the statute of limitations has not run. What Tenneco actually says is that it simply says Latches may bar a claim even if the statute of limitations is wrong.
It may have overstated that.
Yes. I mean, it doesn't change the fact that it is still rare.
Right. And ultimately, we don't
But
believe
they,
that.
all I'm saying is the court in Tenneco never used the word rare, never said rarely.
Right.
Um,
And of course, Your Honor, we would submit that this is not the rare case, given the evolution of the property over time, given the Fraser v. Haney case, the township was well within its right to enforce.
Did
at
Judge
the
Hattie
time.
have the case the whole time?
I'm sorry, Your.
Did Judge Hattie? have the
Oh,
case the
yes,
whole
Your
time?
Honor, he did.
Didn't
So
somebody
this is
take-
what drove him off the bench.
It was one of his last opinions before he
I
retired.
thought somebody took it over after he retired.
It's been reassigned, but he did the final order, so there's never been any proceedings since he retired. Thank you,
Thank
Your
you.
Honors.
Just briefly, going to the latches discussion, in response to Judge Wallace, definitely, I do agree that Tenneco was wrongly cited and wrongly understood by the trial court. And I think if you want an example of a case that applies latches in this type of a context, in our brief, we cited to City of Hancock versus Huter. I hope I'm saying that correctly. 118 Mishap 811. That deals with a legal non-conforming use that later became a non-conforming use under the later adopted ordinance, and latches was applied because the city took no steps over the course of 18 years to
City
do
of
anything.
Hancock it is, you said?
It is City of Hancock versus Huter, which is Hueter.
Did you cite that in your brief? I'm looking at,
Yes, I did cite it it's in our reply brief.
Okay, all right.
118 Mishap 811, 1982. Thank you, Your Honors.
There it is. Yep, it's on page 7. All right.
Thank you.
Thanks.
Okay, that case is submitted. We are moving on to number 8, which is 370621, Quality Custodial versus Beecher Community School District.
Good afternoon, Your Honors.
Afternoon.
Afternoon.
I'd like to say hello to the Honorable Wallace. Apparently, we're both Clarenceville alums, class of
Oh,
88.
right, yeah.
Oh, my. Are
We're Trojans, huh?
Yeah,
Yeah,
you would
the
have gone,
Trojans.
you would have gone to school with my late cousin Dawn Baker, but maybe it's been a while. You might not remember her.
Sing the fight song or?
No,
What year were you at?
1988.
Oh, my goodness.
Oh, my gosh. Oh, my gosh. I am so ancient.
Judge Wallace, what, 2010, 15?
I was 91, so that means your freshman year, you were not, even though you have a first name that's not that common, you were not the only Racine in the high school at the time. I don't know if you recall that.
I never met another Racine.
Okay.
Judge Reardon finished his preparatory studies in 1968, I believe it was, wasn't it, Judge? Or-
No, yeah, the late gate of heaven, yes. I was preparing for the 4th grade. The Tigers, I was following the Tigers.
Nice. Yeah, I followed them that year too.
Good afternoon, Your Honors. It's Racine Miller. I'm here appearing on behalf of Wantoise Davis and Quality Custodial and Residential Cleaning Services. In this case, the question that is before Your Honors is whether additional duties that were assigned by defendant appellee to the plaintiff appellant constituted a modification of the original contract such that we can proceed with our claims. The lower court made a few determinations that, of course, we disagree with, and that's why we're here. In the opinion, 2 things that I'd like to point out to before I hit a couple of high points, and I'd like to reserve 2 minutes for rebuttal, if you please. is that in trying to resolve that question, the court looked to the contract as it should have to determine whether or not there was any ambiguity, and it found none, but we found some. Furthermore, the lower court indicated that when you're alleging a modification of a contract, there's got to be mutual assent, and the lower court indicated that the defendant, through its superintendent, Mr. Davenport, the trial court indicated that Mr. Davenport was not a party to the contract. However, it was Mr. Davenport who executed the contract with Mr. Davis. And that is part and parcel of why Mr. Davis, in this case, relied justifiably on the representations made by Mr. Davenport as it relates to the purported modification of the contract. The contract for custodial services was entered into in September of 2019 and was to go through the end of June of 2021. As we all know, during that time, COVID happened. On January 29th of 2021, during that contract, an email was sent by the school district to Mr. Davis asking that additional duties be performed. About 2 weeks later, on February 11th, a thank you email was generated acknowledging that the additional work was in fact performed. The lower court wanted to know whether or not defendant manifested a desire to change the payment aspect of the contract.
What aspect? Sorry.
Payment, whether or not additional payments would be warranted. And to support that contention, I'd like to direct the court to the actual testimony of Mr. Davenport. He indicated at page 13 of his deposition.
In the appendix? And if so, what page?
I apologize, sir.
Is that in your appendix?
Yes,
And if so, what page of your appendix?
So Davenport
it is page 13 of the Davenport deposition.
Oh, it's
Thank you.
exhibit
Yep,
13
I've
as
got
well.
it. Yep, thanks.
Thank you very much. The superintendent at the time who engaged with Mr. Davis for these services indicated, quote, based on my track record in the district, I believe that any employee in any capacity that performed work beyond their duties should be compensated. And that is something that I try to accomplish under my tenure. Those 2 points aside, it is unequivocally clear by the testimony of the acting superintendent, Mr. Davenport, who executed the original contract and who requested additional services be performed, that COVID did in fact change the way the district did things. Because of COVID, the district's standard of cleanliness, maintenance, and repair had changed. It was something no one had ever dealt with before, and the district had to adapt their day-to-day operations.
What was the time period that the contract was in existence?
Sure, it was September of 2019 until June 30th of 2021.
In that time period, was there a time that in-person teaching was not taking place? And if so, when was it?
There was a time when in-person teaching did not take place, but the buildings remained open for a variety of other purposes. I would defer to district council and stand on my briefs as it relates to the actual timing and duration. And I apologize, I don't have a clearer answer for you. In any event, our point here, and standing on my briefs for a lot of the arguments, I'd like to focus more succinctly on the unjust enrichment aspect, because the only way you can't get unjust enrichment if there is a written contract governing the same. And in this case, if we do look to the contract, which we must, there's a force majeure clause. And that particular clause contemplates that sometimes a contract may not be able to be performed. And in that instance, Oops. Forgive me. That is at the district's appendix 3, page 8. There's a paragraph 11 in the contract at issue entitled force majeure. There are 3 paragraphs in that clause, and the second one indicates, with respect to the inability of a contractor to provide the custodial services as specified in the agreement, that the school district can excuse the contractor from performance. And the second paragraph says that the district may take such reasonable measures as are required to provide or arrange for the provision of the contemplated custodial and maintenance services with no obligation to the contractor other than payment for services rendered through the date of cessation of performance. So our contention is there was a force majeure. COVID is not something that anybody had experienced before. And the incorporation of additional duties, which throughout both briefs are indicated, all of those new and different duties are not standard custodial things. They could not have been contemplated as any and all because they were brand new. It was something that hadn't been experienced before. Under those circumstances and in accordance with the contract, the school district was able to, and in fact did in this case, incorporate new duties into the contract and had the obligation to render payment for services thereby rendered. Dr. Richard Klee assumed superintendent duties a month after the contract ended, and we took his deposition, and he also confirmed at page 9 of his deposition that there were new policies arising from the pandemic. Things invariably changed. And at page 11, that because of the COVID pandemic, there were additional cleaning responsibilities. Marcus Davenport, at page 9 of his deposition, indicated that there were additional requirements for everyone, including custodial staff, insofar as doing things that may have not been the standard way of practice when you're dealing with a new virus. Our contention is that Dr. Marcus Davenport, the acting superintendent at the time, solicited and proposed new terms and/or a new contract by virtue of his email dated January 29th, 2021, where he outlined specific new and different duties to be imposed upon Mr. Davis. This email notably was carbon copied to the board. In this case, Mr. Davis and Quality Custodial were required to undergo COVID-specific training and certain protocols. These were things they didn't have to do under the original contract, of course, because COVID didn't exist. But there were certainly new and different things and new and different expenses that arose. In fact, Mr. Davis did not quit. He continued. He wanted to maintain his obligation to make sure that the students and the faculty were safe. So basically, that is our contention. There was no written contract covering the new and increased deep cleaning. In fact, I believe the district also hired an additional and secondary cleaning crew specific to COVID in the afternoon. So on top of Mr. Davis and his company having their original contract, there were additional duties imposed on his company along with another company being hired. So clearly there were new and different things to be done. He didn't get compensated, and the district superintendent admitted, you do extra work, you should get paid. And that's why we're here today. I will reserve 2 minutes. I'll gratefully receive any questions at this point.
Questions?
All
Thank you.
brief.
Thank you.
Thank you.
Good afternoon, Your Honors. Roy Henley appearing on behalf of the Beecher Community School District, and with me today is my colleague Mackenzie Flynn. who was involved in this file. If I could adopt a phrase from my preceding colleague, this case doesn't involve a lot of adventurous legal analysis. It's very settled law. The Michigan courts have consistently declined to rewrite contracts on the behalf of parties, except in some very narrow and constrained ways with regard to modification. And as we're talking about that, let me address Judge Redford's question regarding COVID closures. Although there is some visceral appeal to saying COVID arrived, we had to become more intensive in what we did. A school district, at least in the respect of cleaning and maintenance, wasn't like a clinic or a hospital or other facilities like that. Based on based on the governor's executive orders, school districts in Michigan were closed from about mid-March of 2020 until January 1st, 2021. So at that point, there was just no cleaning to be done, or very little. Were there students there? No. There may have been the occasional administrator using their offices, but that was it. From January of 2021.
Were there extracurricular sporting activities, things like that conducted at the building in that time period?
I think in January of 2021, that started again. School sports began again.
But your understanding, and you're not sworn an affidavit to it, but your understanding is that the classes were closed and the campuses that the plaintiff had the contractual responsibility to clean were not used for sporting or other extracurricular activities during that time frame.
Right. Not until January of 2021, things started opening up again. The record reflects at that point that approximately 25% of facilities were open. So there were a number of classrooms that remained closed. Beecher Schools is an economically challenged area of Flint. Some kids couldn't attend online, so they were being brought back physically at that point. But it's about 25%, and I think, that shows for what, 60% of the contractors? So the district is either entirely shut or 75% shut. So no matter how you're cleaning, that's less work. And the district never exercised its contractual option for a per diem reduction based on closures. This was a pretty big job to start with, and I think I've got to emphasize that as well, because I think that dovetailed into the trial court's reasoning. If you look at the RFP, pages 12 to 13, I can give you a page cite in our appendix. I think it's pages 85 to 87 in the appendix. The district had 7 buildings comprising about 338,000 square feet of floor area, 762 students in normal times marauding through there. We all know how messy kids are. We've got another 7.
House.
Absolutely. Anyone who's ever been to a school or has been a parent will know that.
Anyone who's attended a school.
Yeah, absolutely.
Particularly the one that Miss Miller and I attended.
I was going to say, Clairsville is
You've got that aspect. And also, common sense tells you there's some areas, they're slogging through the halls in all kinds of weather, bringing stuff in on their shoes. You've got a couple hundred kids in a high school using a gym every single day. You've got a commercial food service. You've got
locker rooms.
Oh, locker rooms, absolutely. You've got cafeterias, which are tragically used to consume foods, and we all have seen what happened in school cafeterias. It is a very big job. And once you shut that down, there's a lot less to clean. There's no question about that. So that goes to the trial court's finding that a directive, just because it's a directive, is not necessarily outside of the scope of the contract. And that's what happened in January of 21, just as things are starting to open up a little bit again. There were 8 elements that the trial court mentioned, and I think it's pretty accurate. One was, let's talk about how we're going to deal with cleaning after athletic events, but there was no directive going along with that. Another one was place a staff member in a school where the school is open to some use. That's common sense. Ensure that the gym is completely sanitized and wet mop. That's a pretty heavy use area anyway. Fog and sanitize the building to the extent they're open for face-to-face instruction.
Right.
All that stuff.
Fog and sanitize. That kind of got my attention. I suspect that was not required before March 2020.
Fogging, no. Not specifically, but then you get into how the RFP was written. And Appendix or Attachment E described the cleaning. And to me, it was like a boilerplate settlement agreement waiver, except in 2 respects. Not the best boilerplate either. So we've all seen settlement agreements that say you waive everything. And then for the next 2 or 3 pages, it goes on and describes what everything is, even though 1 word might have done it. Here it said clean everything on these 338,000 square feet. Goes on to describe what everything is in single space for the next 6 pages. But it also says, A, the list is non-exclusive, and B, that is a minimal standard that those 6 pages require. I think in a school setting, and we've discussed it already, you can't fully predict how much of a mess kids will make.
Right, but I don't think anybody envisioned when they entered into this contract, whether they calculated it with the precision of a laser beam or they eyeballed it and gave a scientific guess. Nobody anticipated the COVID epidemic. I don't suspect if you had polled 100 custodial companies across the state of Michigan, they would have said, oh, and do you anticipate that you're going to have to steam fog, disinfect fog, all these spaces during the pendency of this contract? I don't think anybody would have said that. I don't think that's a very persuasive argument, frankly. What I do think the strength of your argument is there's a contract, it's in writing, and if you're going to modify it, it's got to be in writing. Thank you very much. Have a nice day.
And that's the legal argument right there.
Let me ask you this.
I'm sorry.
Sorry, I interrupted. Go ahead.
If I can address it a bit more, no one anticipated fogging, but it was fogging a quarter of the floor area where the rest of it does not need to be cleaned. So
But it did say in the attachment to the contract, it did talk in multiple parts about having to apply germicidal disinfectant.
Yes.
Yeah.
And so what's the difference between fogging and germicidal disinfectant?
Good question.
I mean, it could conceivably be the same stuff. I think, maybe they were anticipating spritzing some stuff. I think you make a good point, whether you spritz or you fog, it's kind of the same thing. I'm sorry,
So
Judge.
the school district supplied the foggers, right? So they belong to your client.
Yes, I believe so.
I'm an old maintenance guy, hospital and schools and a lot of trash I picked up, but never did fogging.
I'm an old sailor and I swabbed a lot of decks, but I don't think I ever fogged anything either.
What's fogging? You just,
I really don't
it's
know.
like a mister or something?
Yeah, it was something like that. It was never done by quality custodial. I mean, that gets into something that's off the legal.
I never heard of it and I cleaned at Mount Carmel Hospital. I hit the ground floor there.
Wow.
Of cleaning there. So it was quite the job. Yes, I enjoyed it. But we didn't have foggers and that caught my eye. And being in a hospital, that's germ central, isn't it?
Oh, I would think so. Yeah. Yeah. My wife was a nurse for 30 years. So yeah.
This is back in the late 70s, so maybe the germs weren't as
There were no
advanced back
germs then.
Yeah.
I'm not going to let these 2 gentlemen out-labor me, by the way. I spent 3 years cleaning a restaurant.
Go
ahead.
No fogger.
But getting back to
Well done, PJ.
Oh, it's one of those stay in school kids jobs. I mean, certainly. But
I wanted to stay in Mount Carmel. My mother wouldn't let me. So this is great, $5.35 an hour. Go ahead.
Thank you, Your Honor. But getting back to Judge Redford's comments regarding, you needed to modify this in writing, otherwise you're done. That's correct. And that's especially true in the public sector where apparent authority doesn't exist. I don't think we even have to get that far. Mr. Davis, Quality Custodial's owner, was on the Flint City Council for a term. And he very clearly testified in his deposition that he understood the difference between municipal governing board and municipal administrators, including school districts, and that because of that, he understood that only the board could modify the contract.
So speaking of the contract, why does the force majeure not apply here?
It conceivably could have, but no one implemented it. In fact, clearly, Quality Custodial could have been released, or more likely, since there was always a little bit of an opening there, they could have implemented the provision of the contract, providing the pro rata deductions for closure and things of that nature. They never did. It's undisputed. They paid every penny on this flat fee contract. So regardless of whether they could have or didn't have as much to do or what have you, the contract remained in place. Every penny was paid. Quality Custodial is seeking money in addition to what was paid under this flat fee contract. That I would think, given especially Mr. Davis's testimony, was never modified. Under those circumstances, the school district could have canceled the contract, given the failure of compensation renegotiation, and Quality Custodial would have made less money off of it, and there was nothing they could have done about it based on that provision that's very favorable to the district. But here, and this is kind of unusual, I've never argued this in an appeal, regardless of how you look at the contract, the quasi-contract, everything else, damages is an element here that has to be proven, and it can't be on this record. Mr. Davis testified that when he, in an effort to try and get sort of a baseline of his costs, he didn't know what they were, that he just randomly filled in
But
numbers.
this is a SD appeal, right?
Uh,
Summary disposition?
Yes. Mhm.
Okay, so damages were pled, right?
Damages were pled.
Okay, so if there's a fact or a legal or factual question which would preclude summary disposition, that the plaintiff would have had to prove damages, but it's not the end of the day, given the status of the record, if the trial court made a mistake, is it?
I think it could be here.
Why?
Simply because, first of all, damages is ultimately an element of a breach of contract.
No question.
99.9% of the time, especially when something comes on appeal, you're not going to touch that.
Right.
But this is an exception, I think, because Mr. Davis had no records of payroll, no records of costs, no records of material, equipment, supplies. He said all records were either lost or destroyed accidentally. There are no electronic records. He was partially paying his staff with undocumented wads of cash. If for some reason the court were, let me rephrase that, if the court were to remand this, it would still be an act of futility because damages just could not be proven on this record. It's a very rare case to make that argument, but I think that in and of itself here is dispositive as well. So with that, unless there are any other questions, I'll conclude.
No other questions. Thank you.
No, thank you for your time.
As to the uncertainty of damages allegation or unprovability of damages allegation, I just want to point out that the fair market value of services can be used if and when we get back to the trial court. In brief rebuttal, I want to again focus on that force majeure clause. Someone said, district could have canceled the contract. That's not what it says. The clause says that the district shall excuse the contractor from performance. That's not,
But did your client ever do anything to try to implement that force? That clause, I should say?
the clause speaks to what the district can do in the event of a force majeure.
Well, as you just said, it speaks to what they shall do. But I mean, it's debatable whether that clause applied, and if your client never actually tried to implement it, then how was the district supposed to know that your client wanted it implemented?
Thanks. Not that the client necessarily wanted the clause implemented, but that clause ought to govern the party's conduct, specifically in the second paragraph of section 11 of the contract, where it indicates what the district is able to do. And when it's not tenable to complete the original contracted for services, the school district can take such reasonable measures as are required to provide or arrange for the provision of the contemplated custodial maintenance services with no obligation other than to pay. And what the school district did, arguably in exercising this aspect of the contract, was sending the email to Mr. Davis, specifically asking him to do the extra work such that all custodial services could be done.
But the clause in paragraph 11 says, in the event the contractor is unable to provide the custodial and maintenance services. So did your client ever reach out to the other side and say, my company cannot supply these services?
He did not. I'll wrap it up. I know the Brother Council talked about the school district having been closed in some part or access limited to certain personnel. But again, Mr. Davis and Quality Custodial indicated and outlined in an email dated March 12th of 2021 that they had to engage in work that wasn't in the current contract, quote, where work must be demonstrated or initiated to prevent COVID from entering Beecher District. When basketball games or any sports are being played at the field house, my workers have to fog, clean, disinfect, and sanitize all surfaces to protect the public and the players. So I just want us to recall that we're not necessarily talking about the duration and or frequency of the cleaning, but the scope and how the duties were actually performed. That's what changed significantly. There were additional things that had to be done, including training. You required to have additional staff and additional items. I'm gonna wrap it up. Oh, I apologize. I did want to point to one more bit of test. Yes.
Can you tell me, any of those additional things, do they fall outside of the category of applying germicidal disinfectant?
I believe they do. I believe that the manner in which the duration and the type of germicide and the type of precautions that were required increased and were different.
Thanks.
Thank you. All right, so at the end of the day, we've got a request for sending it back to the trial court so that we can proceed on our cause of action at the very least of unjust enrichment. And the law does operate to imply a contract in order to prevent unjust enrichment, only if there is no express contract governing, which we argue the new duties were not part of the express contract. At the end of the day, what we don't want to do is to discourage contractors from, in good faith, continuing to operate when there are emergency or emergent new circumstances, as happened here. We want to allow contractors to endeavor to undertake additional duties as necessary that exceed the scope of the original contract when an emergency or force majeure occurs, as in here. Mr. Davis didn't stop. He continued, and he had every reason to believe that the district would compensate him adequately for the additional work that he performed at their request.
Thank you very much.
Thank you.
Appreciate it.
Thank you.
So that case is submitted. Before we move on to the next one, though, just out of curiosity, Miss Miller, what was your family's name when you were in Clarenceville? Was it Miller? It was what? Ratcher. Okay.
As I said before, go Trojans.
Sure, yeah. I have no idea. Maybe somebody probably liked Greek literature. Yeah, yeah. Well, have a good day. Thank you. Okay, so we're moving on to number 10 on the docket because number 9 was adjourned. Number 10 is 371-393 JS versus AS.
Good afternoon, Your Honors. Dennis Brown, on behalf of the attorney, Jenna Salmon. Very briefly, I would rely on the brief that was filed in this case. But I also wanted to indicate that it's well established that the granting of injunctive relief is within the sound discretion of the trial court and should not be reversed on appeal absent an abuse of discretion. An abuse of discretion is found only if an unprejudiced person considering the facts on which the trial court acted would say there was no justification or excuse for the ruling made. The trial court in this matter did not abuse its discretion when it denied respondent's motion to rescind the PPO under MCL 600.2950(4). The trial court is required to issue a PPO if it determines that there is reasonable cause to believe that the individual to be restrained or enjoined may commit one or more of the acts listed in subsection 1. The acts listed in that subsection include any other specific act or conduct that imposes upon or interferes with personal liberty or that causes a reasonable apprehension of violence. In determining whether good cause exists, the trial court is to consider testimony, documents, or other evidence, and whether the individual to be restrained has previously committed or threatened to commit one or more of the acts listed in subsection 1. In this case, we clearly had that. We had the attack that took place in the Virgin Islands that caused injuries to not only my client, Ms. Salmon, but also her 15-year-old son, Carter. Contrary to the respondent's argument, there was testimony presented at the evidentiary hearing demonstrating reasonable cause to believe that respondent engaged in conduct that caused petitioner a reasonable apprehension of violence. Furthermore, review of case law involving the issuances of PPOs reveal that the types of violent and threatened behaviors that exceptional remedy of a PPO was designed to thwart. Finally, I believe that the Pickering case, which has been cited by the appellant in this, illustrates that even one incident that is reasonably violent or threatening under the circumstances presented is sufficient to support the issuance of a PPO. And for those reasons, we're asking that this court affirm the ruling of the trial court. Were there any questions?
I don't have any questions. The record's pretty clear, particularly from what happened in the USVI. So I don't have any questions.
No questions. Thank you very much. We appreciate it.
Thank you.
So that case is submitted. The final, I'm going to call case number 11, which is 373-112. That case is submitted on the briefs. Case number 12, item number 12, case number 373274. That case also is submitted on the briefs. And with that, I want to thank everyone for appearing here today, and we are adjourned. Thank you.